Nous arrivons de cette manière-là au terme de cette conférence anniversaire autour de la Charte des droits fondamentaux et je pense qu'on peut dire que ça a donné lieu à de passionnants échanges et exposés. Alors en préparant la conférence, je suis retombée sur un article déjà ancien qui était relatif à la Charte comme exemple de codification au plan européen. Et il était listé 3 arguments principaux qui avaient à l'époque été avancés pour justifier l'adoption d'une charte des droits fondamentaux, d'un catalogue de droits fondamentaux propres à l'Union européenne. Et je voulais y revenir brièvement, notamment donc le premier résidait dans le renforcement de la sécurité juridique en rendant visible l'invisible, selon la belle expression qu'avait utilisée Jean-Paul Jacquet à l'époque. Le deuxième argument avancé, qui était d'ailleurs partiellement lié, était celui du renforcement de l'effectivité de la protection des droits fondamentaux au plan de l'Union et de ses États membres. Et enfin, le troisième argument, qui revenait régulièrement, était relatif au renforcement, cette fois, de la légitimité de l'Union européenne aux yeux des citoyens. La Commission européenne évoquait alors un moment historique que traversait la construction européenne, l'Union européenne étant entrée dans une phase nouvelle de son intégration, plus résolument politique. À l'époque, Sébastien Van Rovensbrouck et Hugues Dumont, ici présents, avaient également fait allusion à l'entreprise symbolique de séduction des citoyens que représentait l'adoption de la Charte. Je ne résiste pas d'ailleurs à montrer ce cadeau qui m'a été remis par Nathalie Stockwell de la Commission et qui contient les mini-chartes qui avaient été alors élaborées dans toutes les langues de l'Union européenne, avec comme souhait formulé que chacun, chacune, chaque citoyen européen ou chaque citoyenne européenne ait cette charte dans sa poche au moment de faire valoir ses droits. On est sans doute loin de ce résultat-là, mais ce qui est clair, c'est que 20 ans après l'adoption de la charte, on peut s'interroger sur les objectifs, sur la mesure dans laquelle ils ont été remplis, et sans donner une réponse tranchée à ces questions, il est réjouissant de constater à l'issue de cette journée de conférence que les participants aux 4 panels ont livré des réponses riches, diversifiées, voire contrastées relativement à cette question de la plus-value de la Charte des droits fondamentaux, entendue au sens large, à savoir non seulement en tant qu'outil juridique de protection des droits fondamentaux, mais aussi plus largement en termes axiologiques et en tant qu'élément constitutif, voire transformateur du projet européen.
Pour les conclusions, nous avons très naturellement pensé à Bruno De Witte, professeur de droit européen à l'Université de Maastricht et à l'Institut universitaire de Florence. Co-directeur du Centre de droit européen à l'Université de Maastricht, Bruno De Witte a à son actif quelques 230 publications, écrites en anglais, en français, en néerlandais, en italien, en allemand et en espagnol. Celles-ci portent sur des sujets aussi nombreux que variés, attestant ainsi de la véritable expertise généraliste de notre interlocuteur. Les droits fondamentaux, le droit du marché intérieur, la zone euro, le droit des personnes appartenant à des minorités, le droit des relations extérieures, le droit institutionnel européen. Peu de questions liées à l'intégration européenne ont en effet échappé à sa plume. Nous le remercions donc encore chaleureusement d'avoir accepté de dresser les conclusions générales de cette journée d'études et nous nous réjouissons d'entendre le diagnostic qu'il posera à son père.
Merci Emmanuel, merci Cécilia. Une des règles du jeu des conférences, c'est qu'après toute une journée de présentation et de débat, il faut encore se taper les conclusions, en espérant qu'ils ne soient pas trop longs. Je suis désolé de ne pas être avec vous à Bruxelles aujourd'hui, mais je félicite les organisateurs pour avoir permis quand même cet échange hybride. Je vais passer maintenant à l'anglais pour vous proposer de courtes réflexions sur quelques-unes des questions discutées aujourd'hui. So the first issue I want to reflect on is the use of the Charter as a standard for reviewing the legality of EU action. So the use by the Court of Justice of the Charter in reviewing EU action. This was not really at the center of our discussions today, but this was supposed to be its main judicial use. Well, what we see is that the Court of Justice did not hesitate to find breaches of the Charter by the EU institutions, which it had never done before under the previous system of protection of fundamental rights by general principles. The court had never found an EU legislative piece to be in breach of those fundamental rights. With the Charter, it happened. We already discussed the Testachat case, which is one of the examples. And otherwise, we've had several examples of the right to privacy and to data protection being used by the Court of Justice to strike down directives and also international agreements of the EU. So in this area, in respect of this right, the right to data protection and privacy, the Court of Justice has been very active. Some people would even say has been an activist court. But in other areas and with other rights, we don't find much. There's very few cases, apart from these privacy and data protection cases, where the Court of Justice found action of the European Union to be in breach of the Charter. Why is that? Maybe it's because there were few good cases, few references on validity or actions for annulment, which made a strong argument for violation of the Charter. We all know these cases brought by tobacco companies invoking freedom of expression or freedom to conduct a business to challenge EU directives on regulating tobacco, but there you know beforehand that they don't stand a chance. So maybe not many good cases were brought to the court, but I would argue that in some cases, occasionally, the Court of Justice also showed a sort of attitude of avoidance towards the Charter. Think, for example, of the Belgian case about humanitarian visa. You know, this case in which the Court of Justice refused to apply the Charter to this question. Also cases where the Court of Justice showed a lot of deference to the legislator. For example, the judgment of the General Court, this time in Sotiropoulou, which was a social rights case. Austerity measures imposed on Greece by the EU, of which the General Court said, yes, they were an interference with social rights protected by the Charter, but it justified the interference in one little sentence, which is quite a contrast with the way in which it elaborately looks at the proportionality of restrictions in other areas, such as privacy and data protection. But maybe the fact that there are so few cases is linked to what you could call the upstream effect of the Charter, namely the fact that the European institutions, the legislator, the Commission also when proposing legislation, is aware of the Charter and makes legislation Charter-proof by way of the impact assessments and the other tools that we have discussed today. So maybe that has been a success of the Charter. The fact that so few cases of breach by the European Union have been found is maybe due to the fact that the European Union paid attention to respect for rights. If we look then at, if we don't look this time at the breaches of the Charter, but more at the general Charter doctrine developed by the Court of Justice, we have seen that in the last 10 years especially, the Charter or the Court of Justice has developed doctrines dealing with many of the structural aspects of the protection of rights under the Charter. Things that Koen Leenaerts dealt with in part of his speech this morning. So the limitation of rights, the essence of rights, the horizontal effect of rights, and of course the scope of application. What the Court of Justice has not done yet is to develop a doctrine of positive obligations under the Charter, which is interesting because we know that the European Court of Human Rights has, for over 40 years now, developed a rich doctrine of the positive obligations of states. And it has held that positive obligations can actually arise for all the rights of the European Convention. So you would have expected, given the existence of Article 52 of the Charter, that the Court of Justice might have been inspired by the case law of Strasbourg and also have developed a doctrine about positive obligations under the Charter rights. Now, we haven't seen that yet. The very sort of one of the first signs, a modest start in this respect, happened this week in the judgment about data retention, where the question of the existence of positive obligations under the Charter had been expressly posed to the Court of Justice by the Belgian Constitutional Court. Now, the judgment is 90 pages long, so I'm sure that none of you has read it yet. But if you look at the judgment, you will find that there is a little passage of less than half a page in which the Court of Justice actually admits that the Charter may contain positive obligations, in this case under the right to life, that could counterbalance negative obligations of states to respect the right to data protection. So it will be interesting to see whether this line of thinking will be developed in the future. Let me then move to another topic, which I would say was really the central question today in your conference, and that is the impact of the Charter on the national legal systems. So not so much on the EU itself, but on the national legal systems. Now, in assessing this impact, we have to remember the state of play in 2009, the year when the Charter acquired the legal force of primary law. The Charter did not arrive in an empty legal space, as Cecilia Rizcallah was saying. At that time, we already had a multi-level system of rights protection in Europe. On the one hand, EU member states were already bound to respect EU fundamental rights as general principles when they acted in the scope of EU law. And on the other hand, those same EU member states were all bound by another regime of human rights, namely that of the European Convention of Human Rights. Not only had they all granted to their residents an individual remedy before the Strasbourg Court, but all EU member states at the time had effectively incorporated the ECHR rights in their domestic legal orders. And the Charter, of course, was not meant to displace the existing system of protection under the ECHR. So the question is rather whether the Charter and its application since 2009 has caused a shift in the protection of fundamental rights at the national level compared with that situation in 2009. Now, what we've heard today essentially from the practice of the Belgian courts is that there hasn't been a major shift in the way national courts protect fundamental rights because of the Charter. The Charter is referred to, but often, as was said by several people, the Charter is referred to alongside national constitutional rights and alongside the rights of the ECHR, and very seldom on its own. As an afterthought, somebody said. And of course, what happens here is that the difficult question of the scope of application of the Charter has had, if you want, a chilling effect on practitioners and on judges. It sounded difficult, to know when exactly the Charter applied and when not. And given that difficulty, one can understand why lawyers and courts preferred to use the well-known traditional European Convention of Human Rights, since the idea was anyway that the content of the Charter would correspond largely to that of the Convention. So maybe what I would say is that we should not be too disappointed by the fact that the Charter is not massively used at the national level by either courts or by other users. And I think if we would compare Belgium with other countries, you would see that in other countries it's used even less than Belgium. But maybe we shouldn't be disappointed, because the main purpose of the Charter was not to create new obligations for the member states, but to create obligations for the EU. That being said, it's still true to say that in those 10 or 20 years, we have seen some interesting developments based on the Charter, also at the national level. And I would like to mention here, among the specific provisions of the Charter, especially Article 47, already mentioned by several of the speakers today. Now, from what we have heard today, but also from what we read in the literature, it seems that this right, so the right to an effective remedy and to a fair trial, is the right that is most frequently applied by national courts. Not just in Belgium, but I think that's the same pattern almost everywhere in the European Union. The number one charter right is Article 47. And it plays an important role, especially in fields such as that of asylum and immigration procedures, because the corresponding Article 6 ECHR often does not apply in those areas, since we're not talking there about civil or criminal cases. So using Article 47 has led the Court of Justice to take a close look at the concrete functioning of judicial review at the national level, requiring in some cases the creation of new remedies or new procedures or the provision of legal aid to ensure the effective enjoyment of the rights of Article 47. This has mostly been the case in relation to the rights of asylum seekers, where this article was used by the court to add positive procedural obligations beyond the ones explicitly spelled out already in EU asylum legislation. This leads me then to a further topic, which is the role of the Charter outside the court system, namely in the activity of the other EU institutions. Indeed, the Court of Justice is not the only relevant actor, nor national courts only. We should look at all the actors, and I think one of the merits of this conference was to put a lot of attention to the multitude of different users of the Charter, be it the EU institutions or national institutions, national bodies such as the Equality Body in Belgium, non-governmental organizations, lawyers, etc. Now, when we look at legislative action of the EU, we see, of course, that we have an important set of directives, important legislation that aims at protecting fundamental rights. That's a point which Elise Muir made this morning, to say that we should not look at the Charter in isolation when we look at the EU's role in the field of fundamental rights. Because we have these important directives in the field of non-discrimination, data protection, of course, with the new regulation, employment legislation, etc., which have had considerable implications for the member states. Now you could say, yes, but that's not due to the Charter. That has nothing to do with the Charter. Well, except for some situations like the one that was mentioned to us just half an hour ago by Patrick Charlier, where he showed that even in the area of non-discrimination covered by the directives, it may still be useful for national bodies to use the Charter, namely as a standard for reviewing other legislation in the country. But then there is also a lot of EU legislation that is not about fundamental rights only, but where fundamental rights are one of the dimensions. And there I think the existence of the Charter, and especially the existence of this duty in Article 51 for the EU to promote the application of the Charter, that duty has been playing a role in formulating the way EU legislation has been shaped in other areas. I would want just to mention the area of criminal procedure, where we have a number of directives harmonizing aspects of the criminal procedure, which are very much influenced by the need to protect the Charter, and especially the right of Article 48 of the Charter. So the question in such cases is whether the existence of the Charter has made a difference compared to how that legislation would have looked in the absence of the Charter. There's no easy answer, of course, to that question, but it's an interesting one. I'm coming now to the last point that I wanted to mention, so I promised to be brief, and that is the question of the relationship with the European Convention of Human Rights. If we go back to the Lisbon Treaty, the Lisbon Treaty did two things. It gave to the Charter the binding force of primary law. It also imposed on the European Union a duty to accede to the ECHR. And these two constitutional choices went hand in hand at the time. They were part of the deal of Lisbon. Now, 10 years later, or 11 years later, I should say, whereas the Charter has indeed started to display its legal effects, the accession to the Convention has not happened. And this is mostly the Court of Justice that is responsible for this, through its opinion 213. That opinion has met with very negative comments in the literature, and I think rightly so. And I had to smile a little bit this morning when Koen Leenaerts said that the Court of Justice is not opposed to the accession to the Convention in principle, but it did really make it very difficult in practice. So in the current situation, where new accession negotiations have just started and may never, reach the end, we are in a situation of non-accession. And this has had an influence also on the role of the Charter, in the sense that the Court of Justice has been able to shape the interpretation of the structure and content of the Charter more freely, not being hindered by formal ratification by the EU of the ECHR. And so it has the influence of the Strasbourg case law has been very uneven, I would say, on the case law of the Court of Justice. Again, Koen Leenaerts this morning said that the Court of Justice systematically examines the relevant case law of the ECHR in any fundamental rights case. I'm not so sure whether that's true. There are certainly lots of cases in which the Court of Justice relies on the Strasbourg case law whenever it finds it suitable. There's also cases in which the Court of Justice may offer more protection for certain rights than the basic protection given under the ECHR. But there are also cases, I would argue, in which the Court of Justice basically ignores the relevant case law from Strasbourg. And it can do so relatively freely since accession hasn't happened. So I'm coming to the end of these final reflections. What I would like to say is that, by way of conclusion, is that I think it was Gabriel Toggenburg who said that bills of rights are not self-activating. And I think this conference, and also with its emphasis on the regard croisé, its emphasis on all the actors involved in this field of EU law, have clearly showed that, that the Charter of Rights is not self-activating. And also it should not be left just to the courts. It's not just a matter for the courts. Its use by all the relevant actors can make a difference for the protection of fundamental rights. I think that is a lesson that we have learned from the past 10 years and that we should take with us for the future of the Charter. Thank you very much.